Hey, Assalamualaikum warahmatullahi ta'ala wabarakatuh. So, in this video, I'm going to present case analysis on a GR number 203335 against the Republic Act number 10175. So, these are the petitioners on this case. Si Jesus M. Dicini Jr., Rowena S. Dicini, then Diani, EVP Medina, Janetti Toral, and Ernesto Sonido Jr., the petitioners, versus the Secretary of Justice, the Secretary of the Department of Interior and Local Government, the Executive Director of the Information and Communications Technology Office, the Chief of the Philippine National Police, and the Director of the National Bureau of Investigation, the respondents. So the first is state the fact of the case. So these are the facts of this case. The cybercrime law aims to regulate access to and use the cyberspace. Using his laptop or computer, a person can connect to the internet, a system that links him to other computers and enable him, among other things, to access virtual libraries and encyclopedias to all kinds of information that he needs by research, study, amusement, upliftment, or pure curiosity. Number two is post of billboards like notices or messages, including pictures and videos for the general public or for special audiences like associates, classmates, or friends, and read postings from them. Advertise and promote goods and services and make purchases and payments. And number four, inquire and do business with institutional entities like government agencies, banks, tax exchanges, trade houses, credit card companies, public utilities, hospitals, and schools. And then number five, communicate in writing or by voice with any person through his email address or telephone. So the case arises out of consolidated petitions of the Supreme Court of the Philippines on the constitutionality of several provisions of the Cybercrime Prevention Act of 2012, Act number 10175. The petitioners argued that even though the act in the government platform in combating illegal cyberspace activities, 21 separate sections of this act violate their constitutional rights, particularly the right of freedom of expression and access to information. In February 2013, the Supreme Court extended the duration of a temporary restraining order against the government to halt enforcement of the act until the adjudication of the issue. So this is the fact of the case. So next is the what are the evidences? So the right to privacy. The right to privacy or the right to be left alone was institutionalized in 1987 Constitution as a facet of the right protected by the guaranteed against unreasonable searches and seizures. But the court acknowledged its existence as early as 1968 in Murphy v. Muthok. It ruled that the right to privacy exists independently of its identification with liberty, so it is in itself deserving of constitutional protection. Next is zones of privacy. Zones of privacy are recognized and protected in our laws. So within these zones, any form of intrusion is impermissible unless excused by law and in accordance with customary legal process. To meticulous regard with accord to these zones arise not only from our conviction that the right to privacy is a constitutional right and the right most valued by civilized men, but also from our adherence to the Universal Declaration of Human Rights, which mandates that no one shall be subjected to arbitrary interface with his privacy in every has the right to the protection of the law against such interference or attack. So two constitutional guarantees create these zones of privacy. On A, the right against unreasonable searches and seizures, which is the basis of the right to be left alone, and B, the right to privacy of communication and correspondence in assessing the challenge that the state has impermissibly intruded into these zones of privacy. A court must determine whether a person has exhibit a reasonable expectation of privacy, and if so, whether that expectation has been violated by unreasonable government intrusion. So that is the evidences presented. The next is what is the ruling of the Supreme Court? So ruling for Section 4A1 on illegal access is not unconstitutional. So that is the ruling of the Supreme Court for the Section 4, and petitioners contended that the Section 4A fails to meet the strict scrutiny standard required of laws that interfere with the fundamental rights of the people and should those be struck down. The court has, in a way, found the strict scrutiny standard an American constitutional construct useful in determining the constitutionality of laws that tends to target a class of things or persons. According to this standard, a legislative classification that impermissibly interferes with the exercise of the fundamental right or operates to a peculiar class disadvantage of the suspect class is presumed unconstitutional. The burden is on the government to prove that the classification is necessary to achieve in compelling state interest and that it is the least restrictive means to protect such interests. Later, the strict scrutiny standard was used to assess the validity of laws dealing with the regulations of speech, gender, or race, as well as other fundamental rights as expansion from its earlier application to equal protection. The usual identifying information regarding a person includes his name, his citizenship, his residence address, his contact number, his place, date of birth, the name of his spouse, if any, his occupation, and similar data. The law punishes those who acquire or use such identifying information without right. Implicitly, to cause damage, petitioner simply fails to show how government effort to curb computer-related identify theft violates the right to privacy and correspondence as well as the right to due process of law. Also, the charge of invalidity of this section based on the overbreadth doctrine will not hold water since the specific conduct prescribed do not intrude into guaranteed freedoms like speech. Clearly, what this section regulates are specific actions, the accusations, use, misuse, or deletion of personal identifying the data of another, and there is no fundamental rights to acquire another's personal data. Just about delivers the court's opinion. The government of the Philippines adopted the Cybercrime Prevention Act of 2012 for the purpose of regulating access into use of cyberspace. Several sections of laws define relevant cybercrimes and enable government to track down and penalize the violators for a cybercrime. So among 21 changes sections in the court declared that Section 4C3, 12, 19 of the Act is unconstitutional. Section 4C3 prohibits the transmission of unsolicited commercial electronic communications commonly known as spams. The seeks to advertise, sell, or offer for sale of products and services unless a recipient affirmatively consents, or when the purpose of a communication is for service or administrative announcement from the sender to its existing users, or when the following conditions are represents. And A, the commercial electronic communication contains a simple, valid, and reliable way for the recipient to reject receipt of further commercial electronic messages. Opt out from the same source. And B is the commercial electronic communication does not purposely disguise the source of electronic message. And C, the commercial electronic communication does not purposely include misleading information in any part of the message in order to induce the recipient to read the message. So government argued that unsolicited commercial communications amount to both issuance to trespass because they tend to interfere with the enjoyment of using online service or services, and that they enter the recipient domain without prior permission. The court first noted that spams are a category of commercial speech which does not receive the same level of protection as other constitutionally guaranteed forms of expansion, but is nonetheless entitled to protection. It ruled that the prohibition on transmitting unsolicited communications would deny a person to write to read his emails, even unsolicited commercial ads addressed to him. According to the court, accordingly the court declared Section 4C3 as unconstitutional, and Section 12 of the Act authorized the law enforcement without a court warrant to collect or record traffic data in real time associated with the specified communications transmitted by means of computer system. Traffic data under this section includes the origin, destination, route, size, date, and duration of the communication, but not its content nor the identity of users. The petitioners argued that such warrantless authority curtails their civil liberties and set the stage for abuse of discretion by the government. And they also claimed that this provision violates the rights to privacy and protection from the government's intrusion into online communication. According to the court, since Section 12 may lead to disclosure of private communications, it must survive the rational basis standard of whether it is narrowly tailored towards serving a government's compelling interest, and the court found that the government did have a compelling interest in preventing cybercrimes by monitoring real-time traffic data. As to whether Section 12 violated the right to privacy, the court first recognized that the right to seek concerned information privacy defined as the right not to have private information disclosed and the right to live freely without surveillance and intrusion. In determining whether a communication is entitled to the right of a privacy, the court applied a two-part test. Number one is whether the person claiming the right has a legitimately expectation of privacy over communication. Number two, whether his expectation of a privacy can be regarded as objectively reasonable in society. The court noted that internet users have subjective reasonable expectation of privacy over their communications transmitted online. However, it did not find the expectation and objective reasonable because traffic data sent through internet does not disclose the actual names and addresses residential of office of sender of the recipients, only their coded internet protocol or the IP addresses. So even though the court ruled that the real-time traffic data under Section 12 does not enjoy the objective reasonable expectation of privacy, the existence of enough data may reveal the personal information of its sender or recipient against which section fails to provide sufficient safeguard. The court viewed the law as virtually limitless, enabling law enforcement authorities to engage in fishing expedition, choosing whatever specified communication they want. Accordingly, the court struck down on Section 12 for lack of specificity and definiteness as to ensure respect for the right to privacy. Section 19 authorizes the Department of Justice to restrict or block access to computer data found to be in violation of the Act. The petitioners argued that this section also violated the right to freedom of expression, as well as the constitutional protection against unreasonable searches and seizures. The court first recognized that computer data constitutes a personal property entitled the protection against unreasonable searches and seizures. Also, the Philippines Constitution requires the government to secure a valid judicial warrant when it seeks to seize a personal property or to block a form of expression. Because Section 19 precluded any judicial any judicial intervention, the court found it unconstitutional. So, my takeaways from this case. So my takeaways in this case is, in a cyber world or online world is really prone for a lot of misconduct, and that can be done remotely by the injurious people. So that's why government also take advantage for these gaps of technology in order to protect the people for those unlawful actions that exist online. So I think for the side of government is they just uh, doing their job in order to protect us and to keep our data safe from the other unlawful person. So that's all for uh, this video.